Often bankruptcy and insolvency is seen as a figurative death. However, it can often be a rebirth. The hope of today's discussion is that we will be able to demystify the insolvency process and explain how insolvency legislation can assist in a company's turnaround. There is a difference between bankruptcy and insolvency, and people often incorrectly use the words interchangeably. The term insolvent or insolvency is a generic term used to describe a company or an individual who cannot pay its debts as they generally come due. Conversely, bankruptcy is a legal statement about a company, namely that the company has committed an act of bankruptcy under the Bankruptcy and Insolvency Act. In short, it's best to think of insolvency as a statement of a company's financial position, whereas bankruptcy is a statement of a company's legal position, specifically that a company has committed an act of bankruptcy. The media often refers to bankruptcy protection as a way of referring to debtor in possession restructuring. Put differently, when a company is in, quote, bankruptcy protection, they have admitted to their creditors that they generally cannot pay their debts as they come due, and they're asking for the court's assistance and protection while they formulate a proposal or a plan of arrangement which will be presented to the creditors. Often in the U.S. we hear of Chapter 11 proceedings. That is the U.S. version of a debtor in possession restructuring. In Canada, we have two statutes which debtors can use to seek bankruptcy protection. For companies that have debts of $5 million or more, they can avail themselves to the Companies Creditors Arrangement Act, or CCAA for short. The CCAA is a relatively short statute which allows companies the time and flexibility required for them to restructure their affairs. All companies and individuals can avail themselves to the proposal provisions of the Bankruptcy and Insolvency Act. The proposal provisions of the Bankruptcy and Insolvency Act allow for initial stay of 30 days, stay meaning that creditors cannot sue or enforce on their security during that time, and the courts may extend that 30-day stay for increments of not more than 45 days, providing the total stay does not exceed 6 months. Whether you proceed by way of a CCAA proceeding or the proposal provisions of the Bankruptcy and Insolvency Act, your creditors will have an opportunity to vote on your plan of arrangement. Under the proposal provisions of the Bankruptcy and Insolvency Act, it is very straightforward. If your creditors do not accept your proposal, or even if the court does not accept your proposal, the company is deemed to have made an assignment of bankruptcy. What I mean by deemed assignment into bankruptcy is that by operation of law, the company is immediately placed into bankruptcy. The CCAA proposal, if not accepted, provides a less clear answer as to the future steps. The debtor could continue to operate in the ordinary course. That's highly unlikely. What is more likely is that the debtor will either make a new and better proposal to its creditors, or alternatively, a secured creditor will look to appoint a receiver over the debtor's assets. A receiver is usually a person who is appointed, or a company that is appointed by a secured creditor when a default occurs under its security. Put differently, the secured creditor often has a remedy in its agreement that allows it to appoint a third party, often a trustee, to receive or take possession of the assets for the purposes of selling them and realizing upon its security. A receiver can be appointed one of two ways. The first way is by way of private appointment. What that means is the secured creditor exercises a remedy under its security agreement which allows it to appoint a third party, usually a trustee in bankruptcy, to receive the assets of the debtor and sell those assets in satisfaction of its debt. The other way to do so is by court appointment. What that means is the court orders that a licensed trustee in bankruptcy act as receiver for the purposes of selling the assets. Usually this is done by way of application brought by the secured creditor. Well, there are a number of smaller differences, but the two main differences between a court-appointed receiver and a privately appointed receiver are costs and liability. In a privately appointed receiver, the costs are a lot less simply because you're not going to court for all major decisions. You're simply doing what you need to do in an economically reasonable fashion, and you're completing the transactions. Court-appointed receivership, you are going to court on a consistent basis to get many different acts approved that have been completed by the receiver. The second difference is liability. A privately appointed receiver does not have the protections of court order. Accordingly, There is more opportunity for liability both for itself and for the estate, as there is also no stay of proceedings protecting the estate from lawsuits from other creditors or any other enforcement steps being taken. Conversely, in a court-appointed receivership, the court order provides protections to the receiver and does not allow creditors to sue the debtor for pre-receivership obligations. The short answer is yes. There are a number of formal and informal restructuring tools available to debtors. In fact, we will often use multiple tools to achieve a result on behalf of a debtor. The key takeaway points are as follows. 1, make sure you talk to your insolvency professional earlier rather than later. There are often many more tools available when the company comes to you in its early stages of economic trouble, as opposed to when it comes to you in economic dire straits. Secondly, you should think about the insolvency not as a death, but as a rebirth. There have been many instances where clients have consulted me and we've been able to weather the economic storm and end up with a company that is as strong or stronger than it ever was before.